Okay, so today we're diving into something really fundamental, right? It's this tension, this clash almost at the heart of, well, modern law.
It really is. It's this core conflict.
Yep.
What happens when following the rules, like, perfectly leads to an outcome that just feels wrong, morally wrong?
Exactly. Is the law just a set of instructions, a checklist you tick off, or does it need to aim higher, for actual fairness, for justice?
That's the million-dollar question. And it brings us to these two huge legal concepts: procedure established by law, PL, and due process of law, DPL.
They sound kind of similar, don't they?
They do, but honestly, they represent vastly different approaches. One prioritizes predictability, certainty. The other champions fundamental fairness, even if it's messier.
To make this real, let's think about that story. Carl Lee Haley from A Time to Kill. His daughter's assaulted.
Yeah.
He takes the law into his own hands, kills the attackers.
Right, and legally, by procedure, he's guilty of murder, open and shut, you might say.
But the whole drama, the whole moral weight of that story is asking, does he deserve punishment under those horrific circumstances? Is the strict legal outcome actually just?
And that dilemma, that's not just fiction, it plays out in real legal systems all the time. So our mission today really is to unpack this difference. Where did these ideas come from? We're looking at India and the US.
And crucially, how did India's legal system tackle this?
Yeah.
And kind of evolve, right? Manage to blend these two seemingly opposing ideas.
Exactly. It's a fascinating journey of judicial evolution, finding a way to insist on fairness without completely throwing out legal structure.
Okay, let's start with the first one then, the more rigid idea. Procedure established by law, PA.
Yes, PAL. This
Yeah.
is explicitly in India's constitution, Article 21. It says pretty clearly, no person shall be deprived of his life or personal liberty except according to procedure established by law.
So on the face of it, it means follow the steps laid out in the law and you're constitutionally okay.
That's precisely it. If Parliament passes a law, say, for detaining someone, and it details steps A, B, and C, as long as the government follows A, B, and C meticulously.
Then the detention is legal, even if the law itself seems, well, harsh or unfair.
Correct. The focus is strictly on whether the procedure laid down by the legislature was followed. The doctrine, at least in its original narrow form, doesn't ask if the law itself is just, fair, or reasonable.
So the courts are just checking the boxes. They don't question the boxes themselves.
That was the initial interpretation, yes. It was rooted in this idea of separation of powers. The legislature makes the law, the judiciary just checks if it was followed. It's a very restrained role for the courts.
And we saw this play out early on, didn't we? There was that big case, A.K. Gopalan.
Ah, yes. A.K. Gopalan v. State of Madras, 1950. A landmark case for understanding pure PAL.
What happened there?
Mr. Gopalan was detained under a preventative detention law, a law allowing detention without a typical trial. He challenged it. But the Supreme Court, sticking very strictly to PAL, said, look, we can only check if the procedure in the specific act was followed. They explicitly refused to examine if the act itself, the law allowing detention, was fair or reasonable.
So as long as the paperwork was right, the forms filled out according to the detention law.
The detention was constitutional, even if the law itself might seem, to us now, quite oppressive. It basically meant a law could be technically legal but fundamentally unjust.
Wow. That really prioritizes certainty over, well, humanity almost. It feels like it could lock the system into accepting some pretty arbitrary actions.
It could, and arguably did. And that rigidity, that potential for injustice within the law, is exactly what the other concept, due process, pushes back against.
Okay, good pivot. Let's talk about due process of law, DPL. This comes from the U.S. Constitution, right? The 14th Amendment.
That's right. The language is, nor shall any state deprive any person of life, liberty, or property without due process of law. Again, sounds similar to PAL.
But the meaning ended up totally different.
Completely different legal universe, yeah.
Right.
Because of how the U.S. courts interpreted due process, it developed into two key parts.
Okay, walk us through those. This seems like the core difference we need to get.
Absolutely. First, there's procedural due process. This part is actually quite similar to payee. It means the government has to follow fair steps.
Like giving notice, letting someone have their say, right to a lawyer, things like that.
Exactly. Fair procedures in how the law is carried out. Notice, hearing, impartial judge, the basics of a fair process.
Okay, so far so similar. Where's the big departure?
It's the second part. Substantive due process. This is the game changer.
Substantive, meaning the substance of the law itself.
Precisely. Substantive due process allows the courts to look at the content of the law. It asks, Is the law itself fair? Is it reasonable? Is it non-arbitrary? Does it infringe on fundamental rights without a really good reason?
Ah, okay, so it's not just did they follow the steps,
Yeah.
but are the steps themselves and the reason for them actually just and constitutional?
You got it. It empowers the judiciary to strike down a law even if the procedure for enforcing it is followed perfectly, simply because the law's substance is found to be unfair, irrational, or oppressive.
So this means judges aren't just procedural auditors anymore. They become guardians of, like, constitutional morality.
That's a great way to put it. They have the power, and arguably the duty, to review the wisdom and fairness of the legislation itself, something the early Indian interpretation of PL explicitly avoided.
Let's loop back to A Time to Kill again. Carl Lee Haley. Under strict PL, he kills someone. The procedure says guilty. End of story.
Pretty much, the facts fit the law's requirements.
But his lawyer, Jake Briggins, he doesn't argue the procedure much, does he? He appeals to something deeper.
He appeals directly to the jury's sense of justice, of fairness. He asks them to imagine it was their daughter. He's essentially making a substantive due process argument, even if not in legal terms. He's saying the outcome dictated by pure procedure would be morally wrong here.
And the acquittal, then, wasn't strictly procedural. It was an act of, well, substantive justice, finding fairness beyond the letter of the law.
Exactly. It embodies that due process philosophy, refusing to let procedure lead to what feels like a profoundly unjust result.
Okay, so we have these two paths. PL, follow the established rules, focus on certainty. DPL rules must be fair, focus on justice, give courts more power to check. Can these two possibly merge?
Well, for decades in India, the answer seemed to be no. Gopalan set a very clear PLO path, but then things changed dramatically.
Right, this is the big turning point in India you mentioned, the Maneka Gandhi case in 1978. What happened?
Maneka Gandhi v. Union of India. Monumental. The Supreme Court basically revisited Article 21, the procedure established by law clause.
And they reread it.
They didn't just reread it, they breathed new life into it. They declared that the procedure established by law couldn't just be any procedure. It had to be, and this is the key phrase, right, just and fair and not arbitrary, fanciful, or oppressive.
Whoa. So they essentially read the core idea of due process fairness into the existing PAL language.
That's exactly what happened. It was revolutionary. They didn't need a constitutional amendment changing the words. They changed the meaning of the existing words through interpretation.
How did they justify that? I mean, it sounds like a complete reversal of Gopalan.
It was. They did it by linking Article 21 with other fundamental rights, specifically Article 14, which guarantees equality before the law, and Article 19, which covers fundamental freedoms like speech and movement.
Ah, the golden triangle idea.
Precisely. The court argued that these rights work together. Any procedure under Article 21 that restricts life or liberty must also be non-arbitrary to satisfy Article 14's equality, and reasonable to align with Article 19's freedoms. If a procedure isn't just and fair, it's inherently arbitrary and unreasonable.
So suddenly, Indian courts could examine the fairness, the substance of the law itself, not just the procedure.
Yes. It effectively imported the essence of substantive due process into the Indian constitutional framework. They started calling it ensuring a just procedure.
What does that mean in practice, though, when a judge says a law is arbitrary or oppressive?
It means they can now strike down laws that seem disproportionate, irrational, or unfairly target certain groups. For example, if a law imposes a massive restriction on liberty for a very minor offense, or if it treats similar people differently without a good reason, the court can say, no, this law itself fails the fairness test under Article 21.
It's a huge expansion of judicial review.
Absolutely. It moved the court from just checking procedural compliance to evaluating the fundamental justice of the law's impact.
And this blending, this insistence on just procedure, becomes really crucial when public emotions are high, right? It prevents knee-jerk reactions from overriding fundamental rights.
Definitely. Take the horrific 2012 Delhi gang rape case, the Nirhaya case. The public outcry was immense, totally understandable, demanding fast, severe punishment.
Under the old Gopalan thinking, maybe the courts would have felt pressure to just expedite everything, focusing only on the procedural steps for conviction.
Perhaps. But under the Maneka Gandhi standard, the evolved Article 21, the courts, despite immense public pressure, were incredibly careful to ensure full due process.
Meaning
Fair defense opportunities for the accused, rigorous examination of evidence, the right to appeal all the way up, consideration of mercy petitions. The laws themselves were applied, but within a framework demanding procedural and substantive fairness. Justice was delivered, but it was delivered justly, upholding constitutional principles even in the face of tragedy and anger.
That shows the strength of the system when it incorporates that fairness check. And you see parallels in the U.S. context too, right? Like that movie Philadelphia.
Oh, absolutely. Andrew Beckett, the lawyer fired for having AIDS, the firm, they almost certainly followed all their internal corporate procedures for termination. Checklists ticked, meetings held.
Under a purely procedural view, maybe the firing stands. They followed their own rules.
But the lawsuit and the court's approach embodies due process. It looked behind the procedure. It asked, why was he fired? Was the reason itself discriminatory, unfair, arbitrary? Was it based on prejudice against his illness?
So the court dug into the substance, not just the corporate process.
Exactly. It protected his dignity by saying, even if you follow your procedure, if the underlying reason is unjust and discriminatory, the action is illegal. It's about fundamental fairness trumping procedural correctness when basic rights are at stake.
Okay, this brings it all together really nicely. We need both, don't we? PL gives us that predictability, the rules of the game everyone knows. The state can't just act randomly.
Right. It ensures legal certainty. Everyone knows the steps.
But DPL, or India's just procedure, provides that essential conscience, that moral backstop. It ensures the rules themselves aren't rigged or inherently unfair.
Precisely. It balances the need for order with the demand for justice. The sources we looked at really hammer this home. Law without that element of justice, law that's only procedure, can become a tool of oppression. It risks becoming tyranny by rulebook.
So a legal system that focuses only on procedure, that can't challenge an unjust law or outcome, loses its moral authority, doesn't it?
It absolutely does. It becomes brittle. Modern democracies increasingly recognize this need for balance. The law isn't just a machine. It has to reflect societal values of fairness and dignity.
It's not black and white. It's about navigating those gray areas where the letter of the law and the spirit of justice seem to conflict. That tension keeps the system evolving, keeps it honest.
And that evolution, like we saw in India with Maneka Gandhi, shows that constitutions aren't static relics. They need to be interpreted dynamically by the judiciary to uphold fundamental fairness as our understanding of rights deepens over time. Continuous vigilance is key.
So wrapping this up, the journey, especially in India, shows this incredible effort to blend legal certainty with moral conscience, creating a system that tries to be both predictable and just.
It's an ongoing effort, always. And maybe the final thought for you, the listener, to take away from this deep dive is this. Whenever you look at a law or a court decision or a government action,
don't just ask one question.
right, ask two. First, was the established procedure followed correctly? Sure, that's important. But then always ask the second, arguably deeper question. Was justice actually served? Was the outcome fundamentally fair and right?
Because demanding answers to both questions, that's really how we measure whether a society is truly committed to the rule of law and to justice.